Court of the State of Arkansas. The defendant, Frank Andrew Payne, is, or rather was at the time of the alleged commission of the crime, a 19-year-old Negro youth who was tried for a charge of murder in the first degree in the Circuit Court of Jefferson County, Arkansas. He was convicted of that crime in Jefferson County, took an appeal to the Supreme Court of Arkansas, where the conviction was affirmed, and this court has granted certiorari to the petitioner to hear or to determine 2 points raised in the petition. One, whether or not members of the Negro race were systematically excluded or their number limited in the selection of the jury panel and of the jury commission. And 2, whether the petitioner's alleged confession was introduced into evidence after the same had been illegally and unlawfully secured from him. I should like to argue those 2 points in the order that certiorari was granted, namely beginning with the filing of our motion to quash the then panel on the grounds of racial discrimination. In order to fully appreciate the motion which was filed in the lower court, it should be pointed out that the petitioner in this case is a Negro, that he was charged with the slaying of an elderly white man, and that he was tried before an all-white jury in Jefferson County, Arkansas. The population of Jefferson County, according to the 1950 census, is 76,075, of which 37,835, or approximately 50% of the total population, is composed of colored people. The jury panel is selected from qualified electors within the county pursuant to Arkansas law. And at the time of the trial in the lower court, there were 19,452 qualified voters in Jefferson County, of which 5,774, or 30%, were Negroes. The petitioner, in proper time, prior to the hearing of the case on the merits, filed a motion seeking to quash the jury panel on the grounds, one, that for more than 50 years in Jefferson County, Arkansas, no Negro had ever been appointed to the 3-man jury commission, which is charged with the responsibility of selecting persons to serve on the jury panel in Jefferson County. And 2, that of the persons selected for jury service, that the jury commission was acting in a manner so as to have an inapportionate limiting of the number of Negroes called for jury service in Jefferson County.
What is the term of office of the jury commission?
The term of office of the jury commission amounts to approximately 6 months. There are 2 terms of court each year, and the court appoints a 3-man jury commission a few days prior to the beginning of each term of court.
Is it the practice to change them, or do they go on?
It is the practice to change them, and it is rather definite that it is required by law that they be changed. I think there's a 2-year span between the time that they can serve, so that you do get an entirely different jury commission at each term of court. The terms of court in Jefferson County begin in March and in October. Of course, each commission serves until the next term of court begins.
May I ask, before you get into your argument, is there any literacy test for registering for voters?
Not in the state of Arkansas. The only prerequisite for voting in the state of Arkansas is a payment of a $1 poll tax.
Yes.
And then you are a qualified elector for all purposes under the Arkansas law.
Is that accumulated?
No, sir. You can skip as many years as you want. The only requirement being that it be paid on or before October the 1st of the year preceding the year in which the elections take place.
Are public officials eligible to serve as jury commissioners, the sheriff and such?
I do not believe that they are, Your Honor. I could not answer that question. I know that there are some exclusions by law, but as to what public officials they include, I couldn't answer that.
Well, in this instance, were any of the jury commissioners public officials?
No, sir. None of the jury commissioners were public officials at all. They were proper persons to serve on the jury commission. We only charged the racial discrimination of the selection. This 3-man jury commission is appointed by the court a few days prior to each term of court. And there has never been a Negro serving as a jury commission in the history of anybody who we were able to get to testify who had any knowledge on it at all. There has been a long line of cases from this court and from other courts that there shall be no discrimination on account of race in the selection of petit juries which try the cases, nor of grand juries which return the indictment. In as early as Straughter versus West Virginia, this court said that the constitution of juries is a very essential part of the protection such a mode of trial is intended to secure. We have no case law at all to support our argument, other than to say a fortiori that we contend that such reasoning should also apply to the three-man jury commission which selects the people to serve on the jury panel in the first place, and that the appointment of this three-man jury commission at each term of court is such an integral part of the selection of jurors that if there has been racial discrimination in the selection of persons to serve on this commission in the first place, that is just as unconstitutional as discrimination by race for serving on either a petit or grand jury.
Well, do the jury commissioners for a given term pick the jury panels?
Only for that one term of court.
And how do they do that within a few days before a term?
They are given the poll tax record from the county. And purportedly they go through this entire record of persons, of qualified electors, and select at random or in any manner that they so desire a sufficient number of persons to serve on the jury panel.
How large are the panels usually?
The panels normally in that particular county consist of about 36 persons for the regular panel. Then there's a 25-man special list, which normally is not opened unless the 36-man panel has been exhausted.
And is that panel a grand jury as well as the petit juries picked from that panel?
No, they select really three panels. The jury commission selects a grand jury panel, they select a civil petit jury, and then they select a criminal petit jury. And all of the facts now, which I talk about with reference to racial discrimination, the selection of the jury panel, I have specific reference to the criminal jury only, and I do not have with me, nor do I raise in this argument, discrimination as to the grand jury or as to the civil jury. Now, insofar as the grand jury is concerned in Arkansas, it's something that is just more or less a tradition, because to my own personal knowledge, as long as I have been practicing, I do not recall a single instance that a grand jury has returned an indictment in the state of Arkansas. It is normally done by the filing of an information by the prosecuting attorney. We raise that as a question on certiorari, but we were not granted the right to review on that question. As a matter of practice, it is done by the filing of the information by the prosecuting attorney.
Do you have peremptory challenges?
Yes, Your Honor, we have peremptory challenges.
How many in the criminal case?
In a capital case, the state has 10 peremptory challenges, and the defendant has 12 peremptory challenges. Now, the second reason for the filing of our motion to quash the panel, aside from the fact that no Negroes had ever been appointed to the jury commission, is the fact that we contend that there has been an arbitrary and inapportionate limiting of the number of Negroes serving on the petit jury. Now, prior to 1947, no Negro had ever served on a jury in Jefferson County for more than 50 years. And in the March 1947 term of Jefferson Circuit Court, in a case then pending, the defense attorney filed a motion to quash the then panel on the grounds that there had been systematic exclusion of Negroes from jury service in that county. That motion was granted, and the jury commission was directed to select a new panel. And on that panel, there were some 13 or more Negroes appointed on the panel. But beginning with the next term of court, which was the October term of 1947, down to and including the October term of 1955, on page 25 of the petitioner's brief, we set forth there the total number of persons selected on the panel, and off to the right we have the total number of Negroes who have been placed on that panel. If you will note there, the number of Negroes who have been called for jury service, not for one term of court, but for 17 consecutive terms of court from October of 1947 down through October of 1955, you have only had a total of 29 Negroes called for jury service out of a total of 669 jurors, which constitutes only 4 3/10% of the number of persons called for jury service. If you will note there, it seems to follow a rather definite pattern of limiting the number of Negroes on the panel to just 2 or 3 Negroes per panel. And of course that means that not only in a capital case, but even in a misdemeanor, unless there happens to be a Negro on that panel who satisfies the prosecuting attorney, then it means that the state has more peremptory challenges authorized by law so that they can exclude all of the Negroes on the panel, so that in practical effect, no Negro can actually serve on a jury unless it meets with the approval of the prosecuting attorney.
Did I understand you to say that there are no qualifications whatever that guide the jury commissioners?
They must be persons of good moral character. Is about the only requirement for serving.
Well, is that a statutory requirement?
That's a statutory requirement.
And that's the only one in the statute?
There's no educational requirement. There's nothing else. They're taken purely from the electors. I'm trying to see if I cite in my brief the exact requirement. On the top of page 3, they shall select from the electors of the county 16 persons of good character, of approved integrity, sound judgment, and reasonable information to serve at the next term of the court as grand jurors. And I do know that that is the same requirement for persons serving as petty jurors. Those are the only requirements under the Arkansas law. That is cited under Arkansas on page 3 of the petitioner's brief, under Arkansas Statute section 39-206. Those are the only requirements for serving on the jury in the state of Arkansas.
You mentioned that the state might exercise its challenge, and then by challenge all the Negroes who have gone for that particular petty jury. Do you take exception to that?
Only by saying that because of this inapportionate limiting and having such few Negroes on the panel, we see here that as a practical matter, the total number of Negroes ever appearing on the panel is less than the peremptory challenges allowed to the state, even in a misdemeanor case, to say nothing of a capital case, and that therefore the state could, if it wanted to, use their peremptory challenges to exclude the few Negroes who were actually on the panel.
Do you use that as an argument there must be more than that number on the panel?
No, Your Honor, we do not contend that there should be any certain number of Negroes on the panel. In fact, we don't insist that there should be a single Negro on the panel. We don't ask for any systematic inclusion, and certainly I think we all agree that systematic exclusion is wrong. But we say that a defendant is entitled to a jury from which there has been no racial consideration or discrimination shown. It might be an all-Negro panel, it might be an all-white panel. But we say that the pattern that has been followed is one to inapportionately limit the number of Negroes who are placed on that panel, and that it is therefore discriminatory. That is what we allege, yes, sir. Well, that is the position that we take in our brief.
Well, now, in that connection, are you suggesting that these qualifications in 206 all add up to one thing? This says good character, approved integrity, sound judgment, and reasonable information.
Well, we say that there's no reason to say that there are not a sufficient number of Negroes who possess all of those qualifications.
I'm not suggesting that. I thought you told me earlier that the only qualification was good moral character. And this indicates that, in words at least, there are 4 requisites: good character, approved integrity, sound judgment, and reasonable information.
That is correct.
Well, do they all add up to the one thing, or are they 4 separate things?
No, sir, I think they're separate things. We don't raise that in our argument. It's our contention that there are a sufficient number of people from both races who possess the necessary qualifications, and that the qualifications of the individual juror does not enter into this, other than the fact that we allege that there's a racial discrimination.
But I asked you a question about your table on page 25. Is that the total number of Negro column on the right-hand side? Does that show all the people who were called, or merely those who were on the panel? I mean, in other words, does this exclude the possibility that there were others who were called and for some reason or other were not put on the panel because they asked to be excused, if they weren't found qualified or something?
This includes all of the people who were on the payroll record. And in trying to show the number of persons called, at that time the only information which we could find was that if their names never appeared on the payroll record at some time or another, that there would be no record of the number of the persons who were actually called for jury service. Now, in our brief, we cite the law which requires that these persons must come into court in answer to the service of the summons by the sheriff after having been selected by the jury commissioners, and that if they are then excused from jury service, they are still entitled to $5 per day, even though they may be excused when they come there and show some good cause why they should not serve on that panel, and that therefore the payroll record is probably an accurate record of the number of persons called for jury service, both white and colored. Now, there was some discussion with the trial court when that was offered, in which the court made some statement that persons had been excused by the court without ever coming to court, and that therefore their names would not appear. There was no proof offered on it, and there is nothing to suggest that Negroes were excused in any greater percentage or proportion than white persons were excused.
Well, why wouldn't the names appear if they were paid?
Well, this is the record of the names of the persons who appeared. Now, the law says that if they appear, they are supposed to draw the pay. So we insist.
Are there many of them who forego that usually?
I don't think so, Your Honor. They might, of course, that's not in the record, but in talking with the clerk, sometimes they go maybe several months before they come by and claim it. If they don't come by, he mails them a check or something. But the general rule, they claim it.
Does the law require that they be paid?
Yes, sir. The law requires that they be paid. I think there are some people who have never actually picked up the check, never drawn the pay, but their name is on the payroll record there, and they authorize, they have the right to pick it up if they ever come and call for it. Now, I don't know when the list expires, but the information that we cite here was obtained from the clerk of the court, and the payroll record went back to October of 1947.
Is any statute or any practice shown under which the clerk can fail to put their name on the payroll record if they're summoned and appear?
No, sir. If they're summoned and appear, their name automatically goes on that payroll record. Now, the apparent allegation by the state is that there are persons who are summoned and who get excused without ever even coming to court, and that their names do not appear on the record. Now, if there is such information, we don't have it, and we feel that that burden was on the state to show it. Well, we do not deny it, that it sometime probably occurs, but what we are saying is that there's nothing for us to, we certainly do not concede that Negroes were excused in any greater percentage or proportion than white persons if they sought excuses prior to the time of coming to court. Pine Bluff. Actually, Your Honor, they do have. I'd have to go out of the record to discuss that, because at that time, that was all of the information that we could get. It would. There again, that is not in the record, and at the time that we tried this case, we were not aware of the fact that there was such a record. In fact, the record that we have is the only record that was available to us at that time, the only one that we could find or determine was actually in existence. Since that time, we found that there is another record, but it is not in this record, and I certainly would have to go outside the record to comment on what that record contains. Sir? There is a record in the circuit clerk's office which contains the actual names of persons selected by the jury commission, which differs somewhat from the names on page 25 of our brief, in that it includes all of the persons put on the panel, whether they served or not. And it is, of course, the true and accurate record. We did not use it because we did not know that it was in existence at the time of the hearing. And we only found out about that record subsequent to the trial. In fact, the clerk told us that the payroll record was the only record that he kept.
That's what you were told at the time, some of these records
Yes, sir. He said that that was the only record that he kept, and that unless they had actually served and got on the payroll record, that he would have no record. But now that, of course, is not in the record of this case. Since that time, we have learned that there was a true record, and I have had the opportunity of examining that record. But that was subsequent to the trial of this case, and therefore is not in the record of this case.
Mr. Brown, I noticed that this table on page 25 is based on your statement as a witness at the trial.
Yes, sir.
And you state there that by reference to the names, you were able to tell which persons were white and which were Negroes. Will you explain to us how you could do that?
To explain why I happened to testify, because it's a little bit unusual for a defense lawyer to testify. I had intended to prove this information by the testimony of a deputy sheriff who has been in the sheriff's office for a good many years and who is the person charged with the responsibility for serving these summons. The trial court felt that it would delay the trial to put him on and to have him go down this long list, and suggested and in fact invited me to take the stand and to testify, since I claim to have already made the search. It is nothing unusual in a rural community like Pine Bluff or Jefferson County.
Pine Bluff's a pretty good-sized town.
Pine Bluff is a pretty good-sized town, Your Honor. It's about 40,000 persons. But generally, the jury commission uses the same people over and over for jury service at each term of court, allowing only an elapse of the time requirement that is required by statute in which they cannot serve. And as a matter of practice, you would not find, of the 669 people, for example, listed on page 25, while I do not have the actual record on it, I would say that they are not more than 150 different people. They've used the same people over and over. And for most of this time, the jury commission would insert a C behind the name of every colored person placed on the panel. Now, they just stopped that practice just a few years ago, and if you go back from 47 down to about 52, wherever there is a Negro on the panel, there will be a small C in parentheses at the end of the name, and so they make the designation by race. But, sir, it ended somewhere about 1952. I couldn't be exact about the years, but I know that the first few years, beginning in 1947, the jury commission, in filling out the summons list, would insert a small C in parentheses behind the name of each Negro. And it is nothing unusual in a situation like that, where you have only had approximately 150 different people, and they use them over and over, to not know.
Was the practice stopped voluntarily or because of some specific decision?
It was not stopped because of any specific decision. I rather think that it was stopped voluntarily, or they may have been looking at decisions from other courts and stopped voluntarily. There was no case pending in Arkansas which called it.
Were those Negroes who were on the panel also repeated in the same manner as the whites?
Yes, sir. They were also repeated. In fact, on page 26 of our brief, we say that only 23 different Negroes have ever been called for jury service. And, of course, you've only had 29 calls, so there were some repeats there. And most of these Negroes who have been called for jury service are placed on the panel of persons above the age of 65, and while persons 65 years old and older may serve on the jury panel, they can claim an exemption and are not required to serve if they so elect.
Mr. Brandon, I've rather drawn the inference over the years that these cases have come before us, that things that are not in the record, documented therefore, nevertheless are taken into account of by, as a matter of practice, and taken for granted, counted for granted. And so they can't quite necessitate things outside the record in the usual sense of that phrase. What I want to ask you is this: whether you and the Attorney General would agree on whether or not in the practice of Jefferson County it was found that Negroes on the whole, if they're summoned, are more likely to be asked to be excused than white folks.
I could not agree. I am rather of the opinion, and it has been my experience, that the few Negroes who have been called for jury service are so proud of the fact of having been called that the percentage of persons asking to be excused is less than that of white
That
persons.
may be, when one gets going on this, that may be because they're selected because they would be the kind of people who would serve. However, I won't say that. That may well be.
It is also interesting to note that in the selection of this jury panel, the jury commission is given the poll tax list, and they select their names entirely from the poll tax list. And under Arkansas law, it is required that the race of the taxpayer be shown on that list, so that therefore the very tool which is being used by the jury commission has a racial designation, and they therefore know in advance whether or not they are in fact selecting a white person or a colored person. The 3 jury commissioners testified, and the sum total of their testimony, we think, brings this case squarely in line with Cassell versus Texas. We repeat some of that testimony on page 28 of our brief. For example, in the footnotes there, in asking Mr. Trulock, one of the commissioners, a question, he said, "I felt that in the selection of a jury, I could not take anybody that I didn't know. He might be a better qualified man than I would, but I still wouldn't know it. I was limited to the number of people whom I was trying to select." And in answer to a further question as to whether or not he was personally familiar with very many Negroes in the county who might be qualified as jurors, his answer was, "I don't think I am, sir." And then down at the bottom, Mr. Williams stated that he had race in mind when he selected the 1 or 2 Negroes whose names appeared on the panel. We say that to select persons from a poll tax list that has a racial designation is pretty much the same situation that you had in Avery versus Georgia, where they had put the names of the white jurors on white slips and the names of the Negro jurors on yellow slips. Now, we can't see where that situation is any different from where you go out and select the names in the first place from an official poll tax record that designates the taxpayer by race. We say that the whole of the petitioner's evidence in this case was uncontradicted, and that his motion to quash the jury panel should therefore have been granted. We'd like to move on to the confession, which we contend was unlawfully obtained from the defendant. There is some testimony which is in conflict, as there always is in these cases, and therefore we do not intend to even mention the testimony which is in conflict. The court, under the usual procedure which we follow in Arkansas, first heard the testimony relating to the confession in chambers, and then overruled our motion to quash the confession on the grounds it had been unlawfully obtained, and we went then into the jury room and went over pretty much the same testimony before the jury. The defendant, petitioner in this case.
Could I ask you a question going back to the jury?
Yes, sir.
You said that this practice from 1947 there was exclusion.
Absolute and total exclusion. Yes, sir. There were 1 or 2 cases. The first case that it was raised in was in Washington versus the state of Arkansas, which was immediately following the Wilkerson case where the petition was granted. And the court said in that particular case that because of the fact that in the preceding term of court, the motion was granted and Negroes were put on the jury for the first time, that the petitioners could not come in and say that simply because of the fact that you only have so many in the next term of court, that showed a systematic inclusion or an arbitrary limiting of the number of Negroes. In other words, there had not been a sufficient pattern established. And this is the only case, to my knowledge, to reach the state of Arkansas on this systematic inclusion where you've had a pattern over the years. And of course, the Supreme Court of Arkansas affirmed the lower court. As to the confession, the defendant took the stand in his own behalf and testified that he was 19 years old, that he was arrested while he was at work about 10 or 11 o'clock on a Wednesday morning, that he missed his regular noon meal because he had been arrested, and that he was in the chief of police's office that afternoon when supper was being served, and consequently, other than getting his breakfast on Wednesday morning, he received no food on Wednesday. That on Thursday morning he was awakened around 6 o'clock in the city jail in Pine Bluff, required to remove his clothing and his shoes and socks, that he was then taken to Little Rock without any breakfast, and that he was taken to State Police Headquarters in Little Rock where he was given a lie detector test, and that he was given a sandwich around 1 p.m. on Thursday, and that was the first food in the more than 26 hours that since he had been arrested. The record shows that he was required to take off his clothing, take off his shoes and socks, and in researching the record, I see where he got some shoes back when he got to Little Rock. The record is silent on... according to the record, he was taken naked. Now, nobody asked that question, and frankly, that's a question that has intrigued me upon rereading the record. Well, they were taken off. That's correct, Your Honor. Oh, no, they say that they took them off to examine them for bloodstains, but they also say, in answer to some questions, that they gave him some shoes back when they got him up to Little Rock. No, sir, because the question was not raised as to by either side as to whether or not they ever gave him any clothes back. The only question which is in the record is to whether or not they ever gave him any shoes, and in answer to that, they said yes, they gave him some when they got to Little Rock.
How long was that after they took his shoes away from him?
The police officer who testified said that they gave him some maybe an hour or so after he got to Little Rock, which was about 3 hours after they took them off. Well, I think they took the shoes off the night before. Sir?
Where is that testimony from?
On page 56 of the record, up at the top of the page, the question was, on the morning you got him up...
Is that your cross-examination? That's your cross-examination?
Yes, sir.
What season of the year was
This was in October. This was in the middle of October.
Kind of normal climate, is there? Any normal climate not?
I rather think it was more or less normal climate. A little bit on the cool side, but people put shoes back on by that time in Arkansas.
But they also not.
How's that, sir?
They also go barefoot. That's the extraordinary.
Well, most of them don't. Most of us don't go barefooted as late as October, Your Honor.
I'm an ignorant fellow about it. Large portion.
What would the temperature normally be at Pine Bluff?
Well, Your Honor, it would vary depending, of course, upon the time of day, and I just couldn't answer that. I just couldn't answer that question.
Is that right on the line?
Arkansas is just below Missouri.
I mean, Pine Bluff.
No, sir. Pine Bluff is in southeastern Arkansas. No, sir. It is only 100 miles from Greenville, Mississippi. But it's
fair to infer that an eager cross-examiner like you would have asked him some question if in fact he'd been taken naked to Little Rock. Is that a fair inference to be drawn, considering the purpose of the cross-examination? Would I be stretching much to assume that you would not have missed the chance to prove that they took him naked? The indignity that that involved?
I think Your Honor can conclude that I probably would have asked the question if I had thought that he had been taken naked.
And secondly, that if you you had thought he would, you would have thought about it.
Yes, sir.
All right.
The defendant also alleges that on Thursday, upon his return to Pine Bluff, after this lie detector examination and questioning in Little Rock, that he was taken to Dumas, Arkansas, and locked up in jail down there. That he was kept awake all night by a jailer who threatened him with the same type of treatment which was accorded to a Negro boy over in Mississippi. This was on Thursday night. Now, Your Honor, that point is in dispute. The defendant claims that he was taken down to the city jail in Dumas on Thursday night before his confession on Friday. The state contends that he was not taken to Dumas until Friday night after the confession. Now, they don't deny that those things didn't happen to him down there, but they just say that it happened after the confession and not before the confession.
They say what happened after the confession?
The fact that the defendant was taken to Dumas, Arkansas, which is some 50 miles south of Pine Bluff, where he was locked up in jail for safekeeping because the chief of police thought that there might be some mob action in Pine Bluff, and he was kept awake all night long by the jailer who threatened him with physical abuse and told him that the same thing would happen to him that had happened to a Negro boy over in Mississippi. And while we don't know what he had in mind, this was at or about the same time that the Emmett Till case was in the news every day.
You happen to know the exact name of
That he was taken down there?
Mississippi.
No, sir, I do not. In fact, I know that it was in the news at that time. I do not know the exact date. I do recall that the incident happened in August of 1955.
Supreme Court found that was after the confession.
Yes, sir. Well, they point out the fact that the state says that that was after the confession. I think they agree with the state that it was after the confession. That is the only point in the confession that we say that there's any conflict of testimony on at all.
I'd like to pursue this. Mississippi thing is relevant. It becomes, in my mind, very relevant. What is the relevance that you...
The jailer at Dumas, Arkansas, kept the petitioner awake all night in the jail, questioning him, threatening him, telling him that, and according to the defendant, made remarks that he was going to be hung, and that he, the jailer, would be there when they hung him, and that they would do the same thing to him that they did to the colored boy over in Mississippi.
That is not questioned that that took place?
It is not questioned that that took place.
And it is not questioned
The only thing that is...
preceded the...
Yes, sir, Your Honor, that is questioned. The petitioner says that it happened on Thursday night before the confession on Friday. The state says that it happened on Friday night after the confession on Friday afternoon.
Anything that was more deleterious, carry greater weight for me at least, than if that was said to him, unquestionably said to him, preceding any talk by him.
Well, that's the point that's in
What
conflict.
did the jailer say?
The jailer did not testify. They offered no evidence to contradict that this situation happened. They only say that it happened on the night before the confession. On the night after the confession.
Well, who's
The state.
Well, I know what I'm... If that's to say that somebody's testimony.
Or the state patrolman who took, Sergeant Halsell, who took the defendant down to Dumas, stated that he took the defendant to Dumas on Friday night after the confession. The defendant says that he was taken to Dumas on Thursday night before the confession.
The vital thing is when he was taken. Is that right?
Yes, sir. Insofar as...
As to that, there was testimony one way by the state and another way by the defendant.
Yes, sir. The defendant also testified that he knew of his own knowledge that 2 of his brothers were arrested prior to his confession. He also states that he knows that 3 of his nephews were arrested. And he claims that the chief of police told him that before it was over with, if he didn't confess, that they were going to go out and get his whole family, including his mother. The chief of police, of course, denies making that statement. The chief does admit, however, and substantiates a statement made by the defendant that immediately prior to his confession, at or about 1 o'clock on Friday afternoon, that the chief of police came up to his cell in the jail and told him that there were 30 or 40 people outside who wanted to get into him, and that if he would tell the truth about it, that he could probably keep these people from getting to him.
May I ask this, whether this conflicting, is verifiable from my point of view,
Yes, sir, and we raised...
And then it again was testified to before the jury.
Yes, sir. And as to that issue, which is in conflict, we merely state that part for the record because we take the position that the trial court and the jury had the right to pass on that as a factual matter, and we don't raise that as a part of it at all. But we merely mention it in relating the testimony that we do have here because so many of the other things are not contradicted.
Would you state summarily, without argument, what you regard as uncontradicted, non-conflicting testimony, which, in your point of view, establishes the...
Yes, sir.
Just summarily, one item after another.
The defendant was arrested on a Thursday morning without a warrant. He was held in jail all day on Thursday through the noon hour without any food. He was not given any supper on Thursday night, or rather on Wednesday night, the day of his arrest. He was awakened at 6 o'clock on Thursday morning and taken at least barefooted and with no socks to Little Rock without breakfast. He was given a lie detector test up in Little Rock and questioned all day in Little Rock. He was never arraigned, not even up until the day of his trial. The first time that any question came up about arraignment was on the day of the trial. Of course, at the day of the trial, there's no point in worrying about arraignment at that time. Arkansas law requires, first of all, that a person not be arrested without a warrant unless there's probable reason for believing that the person being arrested has committed a felony. Well, even if they had probable reason for thinking that he had committed a felony, the law still requires that the person so arrested be taken forthwith before the nearest magistrate and properly informed of the charges placed against him and advised of his right to counsel. This defendant was never arraigned, and that is uncontradicted and is admitted to by the parties. He was the chief of police, went up to his cell on 1 o'clock on Friday, the day of the confession.
I wonder if you're not jumping a little. You got him to Little Rock. They awakened him at 6 o'clock in the morning on Thursday, right?
Yes, sir.
And then took his clothes off, and how much they gave him back, they don't know, except that they left him shoeless, stockingless, and took him to Little Rock.
Yes, sir.
All right. Now, did he have breakfast that morning?
He did not have breakfast before going to Little Rock.
Well, did he have...
Go from there.
What about, you said also the day before he didn't have lunch. Did he have no food? Or when did he have food? Did he not have breakfast at Little Rock before he was taken to Little Rock?
No,
Did he give him breakfast later?
No, sir.
Well, then he was kept without food, am I to infer?
He was arrested.
Suppose you state what food he did have.
All right.
Instead of having me ask what he didn't have.
Well, from the time of his arrest at 10 o'clock on a Wednesday morning until the time of his confession at 1 o'clock on Friday, he had a sandwich at about 1 o'clock on Thursday, and he had breakfast on Friday morning.
You had just started by police, chief of police.
Immediately prior to his confession, and following all of the other events which we have alleged, it is uncontradicted that the chief of police went to his cell in the jail and told the defendant that there were 30 or 40 people outside who wanted to get into him, and that if he would tell the truth and confess, that he could probably keep them from getting him.
Did the chief of police testify?
The chief of police testified and admitted on cross-examination that such an event occurred.
How long before his confession?
5 minutes. The man confessed and went downstairs and made the confession orally to the chief, and then went out and got a stenographer and wrote it up.
Mr. Thomas?
May it please the court, the question in this case regarding the systematic exclusion is, as I see it, did the petitioner here meet the burden of proof imposed on him by the rule announced in Payne against Mississippi by showing a conscious and a purposeful and arbitrary discrimination of race in the selection of petty jury? since there were members of the Negro race on the panel at which this petitioner was tried, then the burden of proof is on the petitioner to prove a conscious discrimination by the limiting of the number of niggers on the panel. Now, this the state of Arkansas contends that he has failed to do. Taking the record and staying well within its bounds, on record 11 and 12, some pertinent testimony of the jury commissioner Truelove. Said the question, do you know very many Negroes who would be qualified for jury service? He answers, I think so. Question, do you think of any while you served on this panel? Answer, well, there were quite a few that I certainly would have selected, but they had already served the past year or had some other reason why they could not. Also on...
How many had served the year before?
The payroll record...
Well, they couldn't have served without being on the payroll.
No, Your Honor, they could not have served without being on. The last record was in 1955, which showed a total number of 2 Negroes on the panel.
May I stop you long enough to have you tell me, explain what is meant by his answer? Or they had some other reasons. They had some other reasons for serving. Now, how would that, A, what kind of other reasons, and B, how would those other reasons be communicated to the authorities?
Now, the other reasons, Your Honor, I can't answer. He did explain later in his testimony that he thought some of them lived too far away from Pine Bluff, that it would impose on them to ask them to come in. Some...
He didn't say I had some other reasons for not taking it. He said they had.
He said they, and later on in his testimony he does explain that. But one of the reasons he said that he did not select more Negroes on the panel was because they had already served the previous year, and under the Arkansas law they can only serve once every 2 years.
But you just answered the Chief Justice as to how few they were. So that takes care of 2 or 3 years.
Now,
Well, in the year 1954, there were 2 terms, March 1954, and there was only 1 Negro who would have disqualified himself for that year because he was the only one called, and in the October term there were none called.
Mr. Chief Justice Warren, it reflects this record that you are reading from is the payroll record, which does not disclose all of the Negroes that were summoned for jury service. It reflects only those who actually served on the jury.
Well, if you're summoned but excused before you respond to the summons, you haven't been on the jury, have you?
Well, as a practical matter in Arkansas, the way it works is if you have a toothache or something, you can get on the phone and call the judge and tell him, well, I've got a toothache, I've got to go to the dentist, or I'm sick, or my wife's going to have a baby, and the judge is simply not going to make you come down. Therefore,
I can understand all that. That was the purport of my question to your brother. What I want to know is, what basis have we for assuming that there were these rejections or non-acceptances or non-callings on such grounds?
well, the record is silent as to that. But there is some testimony here between Mr. Branton and the trial judge regarding that particular point. And it appears at 25 and 26 of the record. About 3/4 of the way down on page 25, the court made this statement. You are testifying from the payroll that indicates that is the number who have actually served on the jury. Do you know that the jury commission has selected many other colored people who at their request the court has excused and who did not serve? Mr. Branton, answers, he said, "Are you asking me that?" The court said, "I am asking you if you know that." And Mr. Branton says, "All I know is that from time to time, Negroes have been excused from jury service." And then the court says that their names don't show on this list because they are excused, they don't draw pay, and Mr. Branton says that may be true.
That's hardly testimony, is it? That's a query, isn't it? And not testimony on the part of the court?
Well, I think it's testimony on the part of Mr. Branton. It's certainly a fact that needed clarifying. Now, to give you an example of what
There isn't proof that there are any number of them who were thus excused, is it?
there's no proof in the record as to that. And that's, Your Honor, is precisely the point I'm making. That under the holding in the patent against Mississippi, the burden, since there were Negroes on this particular panel, the burden was not on the state to show how many Negroes had served or had not served. The burden was on the petitioner, and he did not meet that burden because he doesn't show how many were actually selected. He just merely shows how many actually served and was paid. Now, to indicate my point a little further, you will notice that on page 25 of the petitioner's brief, on the October 1947 term, it says the total number of jurors 31 and the total number of Negroes 2. Well, in this Washington against the state in the 213th Arkansas at 218, it involves a trial during this particular term, this October of 47 term. And here's what the Arkansas court said, speaking on the facts. But the proof in this record shows that the 3 Negroes who were member of the regular panel, petty jurors, called in this case. And then they list them, V.T. Price, R.D. Doggett, and Prince Swayzer, and they were numbered 7, 10, and 12. Now then, if Mr. Branton's payroll record is correct, then he's -1 on that very proof alone. In other words, we have a Supreme Court record of the March 1947, October term rather, of 47 in Jefferson County that shows that there were 3 Negroes. Mr. Branton's record here merely shows 2.
Take this at face value, this testimony of Mr. Branton. You didn't contest it down there.
I wasn't there, Your Honor. But the prosecuting attorney did not contest
They
it.
didn't contest
No.
it. They wouldn't even let a state officer give the testimony.
Well, it was delay of time. I don't think that Mr. Branton would deliberately fabricate his testimony, and I doubt that the judge there did either. If I'd been there, I'd have probably agreed to it. Although what I'm saying here now, the burden was not on the state to prove how many were summoned. The burden was on the petitioner to show a conscious and deliberate discrimination, and he has failed to do it. For example, and I think to show...
You mean if Arkansas had shown there had been only one colored man, 15 years, the burden would be on, still remain on the calendar?
It probably wouldn't in that instance, no.
There are some point at which...
There's some breaking point. I notice in the cases like Hill against Texas, in Patton against Mississippi, there had been a great lapse of time in all of those cases where there had been no Negro to serve on the jury. Now here in this case, on the payroll evidence alone, it indicates that they were including Negroes.
May I ask you one question about those who were excused? I'm interested because I take it probably the same practice as other sections. If I understand what you say is that the jurors were summoned maybe a week or 2 weeks before the time. Frequently, some of them will call up the judge or the clerk, get excused before they come to court.
That's true.
But if they come to court in response to the summons, they're entitled to their payment. Get those payments.
Now, I believe Mr. Justice Brenna asked this question, too, about an Arkansas statute in regard to how the jurors are paid. And that is Arkansas Statutes 39301.1 And it reads thusly: persons whose names appear on any legal and authorized grand jury or petty jury list of the respective counties of Arkansas shall receive, in addition to other fees allowable now by law other than under authority of another act, A, when such person or persons fail for any reason to attend court, none. B, when such persons or persons attend court and are excused by the court for any reason from serving as a juror, $5, and then when they actually serve at $7.50. That's what actually occurs. I mean, of course, there's no proof in this record that that happens.
I understand that, but we can accept the payroll not as meaning everybody who came.
As meaning everybody who actually served.
And everybody who actually appeared.
Yes, I believe you can go that far. Actually appeared.
And those who get excused in advance, usually, they have the ear of the judge.
Not necessarily.
Knows how to go up there and call him up in advance and get excused.
I think how easy you can get excused from serving, it depends in large part on how pressing the need is for a juror at the particular time.
But I'm talking about it's a small number that get excused, is it not?
I would say so, yeah.
And it would likely be as many on one side
as the other. Now, to get back to I believe there was one other question that Mr. Justice Harlan asked. In Arkansas, around the 1st of October, it is generally around 70 degrees. Which might account in part for that we in Arkansas don't wear shoes.
That's a good climate.
Sir?
That's a good climate.
Yes, it is.
70 degrees in October.
Hardly ever gets really cold till sometime in January. To get back to on my point here, that the petitioner has failed to show this conscious limiting of the juries, and the burden was on him to show it. Jury Commissioner Bobo, when he was asked at Record 15, when you selected Al Pennington, were you selecting him as just another juror, or were you selecting him with a special point in mind to get a Negro on the panel? And the commissioner answered, well, I don't know that we made anything special of that. We felt like the jury we were selecting was responsible citizens of the county. In other words, that's no proof of any conscious or arbitrary discrimination.
Of what?
Sir?
What's the last word? That means responsible citizens of what?
Of the county.
Of the county.
Now,
may I ask you whether there's any difference in the selection of juries between criminal cases and civil cases?
there is the same method. It's identical.
Is it easy for you to state what the record would show roughly in civil cases down there?
Only in the county in which I am from.
That's what I'm talking about.
But in our county, there's pretty good cross-section on our juries, both civil and criminal.
No, that's a different county.
It's a different county. It is an adjoining county, I believe.
But in this county, you happen to know what the showing would be in civil cases where juries would be?
No, Your Honor, I do not. Now, to get back to the minds of these jury commissioners, where to me the whole answer to this problem lies, is it was the burden of the petitioner to show this conscious discrimination. Now, here is what one of the commissioners, this was Truelove. So do you recall whether or not the names of other 12? Do you recall whether or not the names of any other Negroes were mentioned to the panel? Answer, any others? Yes, sir. Other than the ones that were selected, the answer is yes, sir. Question, how did you arrive at the selection of those that were selected? Did you decide you wanted so many on there, meaning so many Negroes on there, presumably to, the way the question was loaded, presumably to comply with the law or just barely comply? And his answer was, no, we just go down the list and here is a man. We discussed him, what he would do or would not do. Would it be possible to serve or was he too old? What was his work? Just those things. In fact, it is a very difficult operation to get a jury, and we were coming to get anybody we thought could serve. Now that is completely barren of any inference that they wanted to get anything other than a representative jury. And his...
May I ask you this question? What inference do you think is allowable, if any inference is allowable, from the fact that in a county in which the population between colored and white and colored is about half and half, as it is in this county, and the process by which jurors get on panels runs over a course of years from, let us say, 30 to 60 as to white, and never more than 6, only once, as I noticed it, run from 0 to normally 2. What inference is allowable that there is not operating an individualized judgment each year, but some predisposition in the selection of people which already makes a classification that you want more of whites than of color?
I don't think that you...
I'm asking you
what I think would be the fair inference. I don't think that based... now, I'd have to draw two inferences from your question. One, that the number of Negroes, as you said, ran from 0 to 6. I'd have to assume that list included all those who had been selected
well,
to
the
serve.
difference couldn't be much. The margin of error couldn't be large, could it?
Well, 1 or 2, it might double it or lessen it.
Well, then say 4. It runs never, on the average, 4 a year. It's much less, I believe, the figures for the Negroes are great benefit. Let us say the average of Negroes is never above 4, and the average of white is never below 30. What inference is allowable, if any? This is not an argument. This is a real question.
I don't think there's any inference allowable from that.
You can't even say...
Now, you said the population was equally divided. That is true, but when it comes down to the number who are qualified to serve as juries, then it ceases to be 50-50. Then it comes down to something like 1/3 and 2/3.
Well, when you say qualified...
That, in Arkansas, is having a poll tax. Plus the other 4 things that are set out by the statute.
Well, does the record show what the base of what the pool from which white and colored are drawn is?
Yes.
Are?
It's set out in both briefs, Your Honor. Page 24 of the petitioner's brief. And at page 15 of the respondent's brief.
May I ask you, you've looked up government census to see what percentage of colored people in the county are educated with a high school education?
No, sir, I have not.
Is that unusually low percentage?
I have no idea. Judging from the makeup of that particular county, it would be my guess that there's a great amount of illiteracy because it's largely an agricultural county. It is changing somewhat now.
What you're saying, what your state's position, see if this is a state's position, that nearly on the face of the figures, the pool of white, the pool of color, have been disparity to which you refer. Nearly on the face of the figures, in the light of no human testimony, that in fact bias determined the selection. elements that enter into the area of judgment that is open to the jury commissioners might well work out this way. That's the state's position.
I believe that's. But this court has many times held that no race is entitled to proportional representation.
No, I'm not suggesting that. I'm merely suggesting that in one of these cases, the dice don't always fall the same way. And one assumes, or what is required, is a judgment subject to all the non-provable fair basis of discretion. They shouldn't enter consciously or unconsciously, an exclusionary consideration.
I think that they have to show that that in the jury commissioner's mind there is an intent to discriminate. And I think that the only way you could show it, even backing up, apparently as you are, over a number of years, that you could not take the jury commissioners one isolated instance and bring the jury commissioners in and have them testify. I think you would have to go back to really prove it. To go back to the jury commissioners and at each term that they were selected and examine them.
Well, intent is an ultimate judgment of inference on a lot of non-demonstrable facts.
That's true.
But doesn't it seem strange to you that in about 16 or 18 terms of court over a period of nine years, that once there were 6, another time there were 4 Negroes, and on no other occasion was there more than 2. And on a good many of the times there were 1, and several times none on the panel. Out of 5,774 qualified electors. Doesn't it seem to you a little strange that would become the pattern?
Not when
that would be the extent to which any one of those panels would have colored people on them?
I think if you look at it from a mathematical viewpoint, which I know sometimes this court does, from the number of white people selected, which Mr. Branton, I believe his record shows 669. If you'll re-add the column, it's 640. The number of white persons who have served in relation, in their ratio to the number that have poll taxes, and we presume they're qualified, meet the other 4 requirements, then only 4.68% of the qualified white persons have served over the same period of time. So I don't think that that's any criteria.
Well, could you give me some rational explanation of the October 1954 term, which is the same as about 5 others, in that there are no Negroes on the panel?
October 55?
October 54. They had 39 whites on that jury, and not a single Negro. Now, would you just give me some rational explanation as to how that would happen if they were trying to give a cross-section of the county in establishing this jury panel?
Now, of course, you're having first to speculate that none were chosen, because this is not an accurate record.
You have no evidence in here that there were any so excused. You have a question by the judge, but there is no testimony in this record, as I see it, that any Negroes were excused before they came in here to respond to the subpoena.
Well, as I understand the holding in Patton against Mississippi, the burden was not on the state to prove that.
That's the only answer you have to it.
That is correct. I mean, I don't know. I can't speculate or draw an inference from jury commissioners that I've never seen and don't know. I don't know what they were thinking. I grant you it does arouse your suspicion somewhat. That's probably true. But what I'm getting at is this is not the complete picture. And it's somewhat the same situation that
Did the state make any effort to show what the true picture was?
No, none.
Didn't we see it here versus Louisiana, where there was a very great disproportion, or even none at all, and over a period of years, that was shown. The government and the state failed to show why there would be such a disproportion, and it failed to perform its duty.
I believe in the Pierre case, there was a showing that for a great number of years there had been no Negroes on the panel.
Now, suppose here, suppose in all these years it's shown each year they put one. Would that be any different?
It probably wouldn't if it were consistently come up with one on it.
Well, when it consistently gets this
However,
low, when it consistently gets this low, with such a great number of colored people there, is it possible to draw any inference that could happen accidentally, unless you say that the jury commissioners just didn't know?
Well, it's possible that they didn't know. It's possible that they knew some and they didn't think they were qualified. There's many probables in it.
Have we also said that if they say they don't know, not knowing them is
In
not
the
enough?
Cassell case, yes. But in the Pierre case and in the Patton case, where for a great number of years it is shown that there have been no Negroes on the panel, then they have made out a prima facie case of discrimination, and the burden of proof then shifts to the state to bring on some evidence to prove why there were never any selected. But here I think there is a difference, because here we know some have served in practically every term of court.
A very, very small percentage.
That's true.
To the two.
That's true, according to the
And with
payroll
no
record.
reason at all, except guesswork, as to why that should so consistently happen.
That's true. But I think that this court will have to change its past decisions.
Which one?
Let's say Patton against Mississippi. Or even, let's take the Brown against Alley. There, the jury commissioners, I believe they were selecting a grand jury, very frankly stated, and it's in the record, it's in the report, that they didn't intend to select but one Negro for the grand jury, and after they got him on there, they were through with the Negro question.
I think, as I recall it, maybe I didn't say it in that case, but as I recall it, there was something said there about the fact that they had shown a breaking away from the old pattern of the past.
Well, that's true, but I mean, taking this record from what was happening prior to the Wilkerson case in this particular county in 47, it's changed radically, too.
Well, that's a period of...
It's a period of...
change in 47, that made the change.
Well, I think this brings us up to 55. But it's some change. From none to some.
That's right.
That's right. This is not the complete record. That, under the decision in Patton against Mississippi, he failed to meet his burden.
But didn't he tell us that it was represented to him that there was no record except the one that he did get? It wasn't until later that it was disclosed, or
Well, I
we
think
somehow
that-
learned that there were other records.
I think that he said this, that he asked Mr. Meade, who is the county clerk, was there any other record? And Mr. Meade said, I don't have any other record that would indicate. And I don't think he searched any further than that one. Sir?
Who did have another record?
I believe the sheriff's office.
So the public record
Yes, sir.
required by the statute to be kept in the
Yes,
sheriff's
sir.
office? Is that statute quoted in?
I don't have that statute, but it's the statute on summoning the jurors. They have to have a summons with their name on it and their address, which is kept permanent record in the sheriff's office. And I say this, that this record could have been complete with a little more, if he'd just gotten that in. Then we'd have a complete picture of it. And I'll confess, I'm as ignorant of the true facts as anyone. But I do know this, that this list, or the number that he say it actually served, actually appeared. That's true. I'll accept his testimony on that. But I'll say this, it is not the actual number who were selected.
Doesn't the record show that he tried to prove this through the sheriff's office and the judge wouldn't permit him to do it?
Well, Your Honor, it was the same record that he had searched. It was the record from the clerk's office, sir.
There wasn't any particular record. They wanted him to consult the records and find out how many it was, and the judge said, that'll take too much time. We can't do that. You do it. You've made an investigation of these records. You use your information.
The judge...
He tried to get it from the sheriff, didn't he?
No, sir.
What did he try to get?
The record that he was attempting to have this other gentleman testify from was the record from the county clerk's office, which is the identical record that he had searched and already knew the numbers. So in order to expedite the trial, the judge asked him, haven't you searched the same record? And he said, yes. He said, well, put the testimony on by yourself, otherwise we'll have to sit here while this man reads some 40 pages of records.
Did the state make any objection that this is the correct record?
No, sir.
May I ask you now, you know the system. Have you any reason to tell us, Assistant Attorney General, that the other record would make any substantial difference?
I think that it would, possibly, maybe not over 2 or 3 more on each panel. I wouldn't venture more than that.
I think it might possibly show that 2 or 3 were someone that didn't come.
That's true. And it might show 4, 5, or 6 white that didn't come to.
Probably about the same percentage.
I would think so.
Probably a little more of a white.
I doubt it.
You did?
Do you happen to have any light on why from 47 to 55 figures on the whole run pretty uniformly, except in 4 instances there's considerable variance. 64, now the total number of jurors is white. 64 and 50, 64 and 51, 50 and 52, and then in 55, 58. Which, considering the smallness of the number, the percentage of increase from the average and the norm is rather considerable. Do you happen to have any reason why at the March term of 50 days is 64, and the October term of 49 is 32?
There's nothing in the record for me to base.
Season got anything to do with it? October. I noticed that that's true, because 2 of the increased numbers happen to be in October, 2 in March, and 2 in October.
Do you summon a bigger panel? You have capital cases?
Ordinarily, if there's a lot of feeling about it, the answer would be yes, they would summon more.
Because there are more, before there's more challenges.
That's true, and then, of course, if a prospective juror on his voir dire examination would say that he doesn't believe in capital punishment, why, he'd be crossed off, and so it does take a greater amount of venirement for a capital case.
You don't have special analysis.
Sir?
You don't have special analysis.
We have what we call special panels that are picked by the jury commissioners at the same time they select the grand jury and the petty jury.
I mean, capital cases, because you summon a greater number of jurors, prospective jurors for that minority.
Yeah.
That's a special analysis.
Yeah. A list is always available, and then, of course, if something like this is coming up, then they can summon them. But I think possibly that this case stands pretty much in the same situation that United States against Brant in the Northern District of Ohio, which was a 1955 case, 139 Federal Supplement, where we're making the same claim as they're making here, that Negroes as a class were excluded from jury service. However, in the Brant case, the record was clear that throughout the years covered by the evidence, colored persons were represented on the jury list and actually served as jurors in the cases. And that's the same thing that we have here. The court said, to sustain this claim, defendants rely in part upon the fact that no member of the indicting grand jury was a Negro. But their contention that this is evidence of discrimination is devoid of merit, because it's well settled that an accused person is not entitled to have a jury composed in part of persons who are members of his own race, nor is anyone entitled to that. And then they cite the Martin against Texas in 200 U.S. and Akins against Texas in 325 U.S. Now, I think that the Akins case is probably the complete answer to this one. And the language of this court in that case is that the petitioner's sole objection to the grand jury is that the commissioners deliberately, intentionally, and purposely limited number of the Negro race that should be selected on said grand jury panel to one member. Now that's what he's saying here, that we have systematic inclusion rather than systematic exclusion. And this court said fairness in selection has never been held to require proportional representation of races upon a jury, citing Virginia against Rives and Thomas against Texas. This court further said our direct... Sir?
The other side disavows any such trying to maintain any such principle, don't they?
I'm sure.
They don't. As I understood Mr. Grant, he said he didn't make any such intention. His brief doesn't. His brief excludes that.
But I mean, I think what he's saying, though, that the fact that the number of Negroes were so small on the jury panels, that would show inclusion, systematic inclusion. But to follow that line of reasoning further, then the only way a state could ever prove that there was not systematic inclusion then you'd have to go to the proportionate basis.
Systematic inclusion isn't a law, isn't a legal doctrine. All it was meant is that you do not satisfy, you do not disprove prohibited discrimination by saying, well, we'll have one Negro or two. In any event, that will satisfy the requirement or disprove systematic discrimination. He wouldn't object there if he systematically included more Negroes than anybody mathematically required.
He seems to be objecting, though, because we're not...
He wouldn't object to that. He wouldn't be here. So we've had a case where a white petition objected to the failure to have colored people on the jury.
Well, he seems to be objecting, though, Your Honor, that we haven't included enough.
Well, that's what discrimination is. That's included enough to be convicted.
But it's still the state's contention that he has not met his burden of proof, because we don't know how many that were actually selected. And the only way we can arrive at any figure on that would be by speculation and conjecture.
What he says is that you do not disprove his claim of intentional discrimination by saying, well, look, each term is quite so. But each term we did have one Negro. You do not satisfy the principle. inadmissible exclusion by including a total colored man.
Well, now, Your Honor, I believe...
I'm not saying that's this case. I'm saying that's his position. Your answer is that he has a burden of showing, no matter what the figures show, that the figures are as a result of the intention of keeping out colored people from serving who should be allowed to be on the panel.
And I think to prove his claim, then he must show how many were actually selected, not how many actually served, which is all his record shows here. And if it were like your example there, just one every time, then I'd agree with you that.
Why would that settle? People can be, things could be done in such a way that those selected, it was known in advance they would serve. And that has come up from time to time. Documented with something. Everybody knows that few, various others. Why therefore do you say that? You have to show the number that was selected first.
Well, I mean, if you're ever going to prove discrimination, then I think you must show the actual number that were selected, because the discrimination lies in the selection rather than in the serving.
Suppose these figures show, suppose that whites that had 8 vote bags for 5,000. Colored that 8 vote bags for 18,000. You still had these figures. Would you say that
I'd say the petitioner had a much stronger case.
Well, would you still say that nobody could infer from that?
You mean from the number that were actually served rather than from the number that was selected? I'm afraid that I'd probably have to infer that there was some discrimination.
And suppose it's reversed the other way. The number of white people that served was 39. The number of colored people was 669. How would you feel about that? Is that no discrimination?
You mean with the same number of qualified electors?
Just like it is.
Probably wouldn't. I'd like to briefly discuss the petitioner's confession. And I believe Mr. Justice Frankfurter said to set out the grounds that I believe it was coerced. Well, the petitioner's grounds, he alleges, one, that he was mentally retarded, that he was arrested without a warrant, that he was interrogated constantly, that he was deprived of food, threatened by mobs, and that he was held incommunicado, and that the chief of police had threatened to arrest all members of his family if he didn't confess. Now, if all these things were true, then I would not hesitate to tell this court they should reverse it, because in my mind it would be coercion. But the only thing that I know to do in explaining these things is go to the record and see what the testimony is. Now, Mr. Branton, I believe all of the facts as he gave them was based on the testimony of the petitioner. And since he was on trial for his life, he might be excused some latitude in his testimony. Let's go to the...
I wonder if it would disturb you if it will do it. Mr. Justice Frankfurter asked me, Mr. Branton, to state, if you would, what he considered the undisputed facts of what can be so coercive. Would it disturb your argument if you would just state what you conceded would be facts, undisputed facts, insofar as the coercion issue? And first,
all right, there's only one. And that is the testimony of the chief of police. When he told the petitioner, he was the chief of police, was on cross-examination, was asked by Mr. Brandt, did you tell the petitioner that 30 or 40 people were likely to be there in a few minutes? And he said, I said there could possibly be that many, and there possibly would be. Now, I frankly, and in all truthfulness, do not know whether he meant they were coming there to witness the confession, that he told them there was a mob outside. The record to me is not clear, but that is the only questionable incident in this whole record.
How long was that supposed to be?
About 5 minutes.
Would you point to the page on
Record 69. It's about 12 lines down. Question is, state whether or not you told him, the defendant, there might be 30 or 40 people there in the next few minutes. Answer, I said it was possible. Now, to me, that is the only piece of evidence.
where is the piece of evidence where the defendant said you told him there might be 30 or 40 people there?
It's on record page 69.
I mean, the petitioner's evidence that was saying there'd be 30 or 40 people there.
Well, now this...
What did he say was the reason?
What did the petitioner say? He said that there was, that the chief of police told him that there were 30 or 40 people that wanted to get him there to get him, I believe is the way he put it.
Was the chief of police, did he make any further statement than this about it at all?
To my knowledge, this is it on page 69.
Well, could you quickly turn to the testimony of the petitioner on this very point? What is his account of this 30 or 40 people?
I believe 128. The bottom of the page. Question, what caused you to be afraid, Frank? Answer, well, it were the conversation that Chief Norman Young was talking, what he said. 30 or 40 people's outside. Then from the conversation of this officer down at Dumas, the way he was talking. In other words, he says people's, it were somebody outside and were someone that was outside wanting to get into me.
This officer down at Dumas, that's a different...
That happened a different night. The record is clear on that. This, but this...
After that, is that also unquestioned? Is there also agreement on that?
Only as to what is in... What happened at Dumas is very clearly happened a night later. There's just, the evidence in the record is just abundant on that.
After the confession?
What occurred at Dumas
Was after the confession?
was after the confession. I don't think there's any question about that. And I have the record cited to show that it happened after the confession at 58, 60, 66, 90, 91, and 106. Now, at record 91, now this is petitioner testifying. He forgot himself here. And what was this statement the man said to you about hanging somebody? Answer. And the petitioner is testifying. And he has a mental lapse here. He wasn't on guard. Well, he was questioning me. As I said before, he was questioning me. Had I confessed that I did it? And I told him, yes, I had.
Now, at the top of page 128.
128?
I believe he said, with reference to the same conversation that the chief testified about, he believed. Chief Norman Young said 30 or 40 people were outside wanting to get into me. And he asked me if I wanted to make a confession, he would try to keep them out. Did the state ask the chief whether or not that was true?
Yes, sir.
Where is that?
Page 69.
Page 69.
I believe it was Mr. Brandt was cross-examining the chief on that point.
But where did he deny that?
to state whether or not, it's about 12 lines down on page 69. State whether or not you told him, the defendant, there might be 30 or 40 people there in the next few minutes. And Chief Young answered, I said it was possible.
Well, that's pretty plainly refers to the statement that this man made that he said there were 30 or 40 people out there waiting to get him.
Well, now, it goes on here is the reason that I have a question about...
Did the state ever, did the policeman ever deny, the chief police ever deny, that other part of the statement that was made about the 30 or 40 people?
To my knowledge, he didn't. This is it. He just says, I said it was possible. And I think there's another place in the record somewhere he was testifying about it, and he says, I said it was possible there could be that many, and he said it was possible there would have been that many.
You say
That's the chief of police.
I understood you. You say that is, according to your view, in answer to Justice Black's question, that's the only thing that is, as to which there is agreement between the petitioner and the state witness.
That's the only thing I think that you might infer any coercion from. That would be the only statement in the whole record.
No, there's no controversy that the chief of police said something about 30 or 40 people in the next few minutes. Is that right?
That's right.
All right.
But then he goes on, right on page 69.
Nobody ever denied the statement of petition that the chief of police told them that they were out there to get him.
Well, I wish you would note, Mr. Justice Black, how this question is phrased on page 69. You notice that he doesn't mention anything that 30 or 40 people to go in there to get you. He said there'll be 30 or 40 people there in a few minutes.
I understand.
Now, there were several people that did come in after this confession who witnessed it. Now, I don't personally know and can't gain from the record whether the chief was referring to the witnesses or he actually did say something about a mob.
But the fact remains, does it not, that you have a statement by the petitioner. He said there were 30 or 40 people, and he said they were there to get him. You have no denial of that in the record by anybody representing Arkansas.
I believe that's correct.
Well, that isn't quite his testimony, because the answer includes not only the conversation with Chief Norman Young, but also with that officer at Duma. And that's not the truth.
Well, now, I believe you're on a different page.
I'm talking about page 128.
Look at this.
Well, I was talking about page 69.
Well, I understand that. I'm talking about something else.
All right.
Testing myself. I understand that. Your argument is the chief of police simply says 30 people there in the next few minutes without saying what the people were there for, what their purpose was. And it's correct, isn't it? That's yours.
That's true.
Now, what I'm turning to what the petitioner said on page 28, 128. And the petitioner gets in the phrase, to get into me. He concludes that after referring not only what Chief Norman Young said, but also what the officer down at Duma said.
That's true.
That's at the bottom of the page.
That's at the bottom of page 128.
What about the top of the page? Is that disputed?
Only the part says wanting to get into me.
Well, has that been disputed by him? He would try to keep them out. Has that been disputed by him?
In your brief, on page 11, counsel, of your brief, 2 lines from the bottom of the page, you stated, as apparent that what Chief Young meant was there would be other people there to witness the confession. Now, where is that?
That is what I get out from page 69, because when you come on down and read in context, without taking it out of context, if you take it out of context, look, you don't know. But if you go on down close to the bottom, let's see.
But the thing that's wrong with that is that when somebody did knock on the door to want to come in, he wouldn't let anybody in, even though he was the sheriff, to witness the confession.
That's true. He in his testimony, the sheriff said, I had promised Frank, the petitioner, that he could make this confession to me in private. And he kept his promise, and he wouldn't let anyone else in, he testified, until he got Frank's permission.
So that all adds up against what you say in the bottom of page 11 as to the reason that he was...
I don't think so if you read it in context. On 69, Right after he said, I said it was possible. Did you go downstairs to the office? Yes. Was his confession interrupted? Says it was by a knock on the door, and he went to the door. He said it did, and the sheriff and a state trooper were at the door. Did you permit them to come in? I did not. Did you tell them anything about the defendant? He said, I told them that he was making an oral confession, and said, did he complete his confession? Roughly. Then what did you do? I asked him if he would mind the sheriff and Sergeant Halsell coming in. How much later was that? He said, not more than 5 minutes. Question, then did the other people come in? Connected back up here, there'd be 30 or 40 there. Reading it directly in context.
What you have here, I wish you would state whether or not you think that shows the confession was coerced or not.
I do not.
Well, let me ask you this question. You have undisputed testimony to this effect. No witness has denied it. Chief Norman Young said 30 or 40 people were outside waiting to get into me. And he asked me if I wanted to make a confession, he would try to keep them out. Now, nobody's denied that. In your judgment, if that is true, was this a free and voluntary confession?
I think it was.
Even with that statement?
For this reason.
Even with that statement made?
I don't think possibly the statement, as you put it, was not denied as such. But during Chief Young's testimony, he explained it in a different way. I mean, he answered the questions in a different way where you could possibly draw any inference you want to.
You made no statement on earth about whether the 30 or 40 people there, the statement was true, that he had told this young fellow that there were 30 or 40 people out there waiting to get him.
But the reason that I think that it wasn't coerced is his subsequent demeanor after that. That is shown by the testimony of the court reporter and the other witnesses to the effect that, well, a few minutes later, here he is testifying, and he was watching the court reporter take the notes in shorthand, and he's very careful not to talk too fast so she'll get everything down that he's saying. And he shows no outward signs of fear. And that would lead me to believe that there's just no substance to the argument of a coerced confession.
But you do have to defend it, do you not, on the basis that there's undisputed testimony in the record. The chief of police told him 5 minutes before the confession, you better go ahead and talk to the 30 or 40 people out waiting to get you.
Well, it depends on whose testimony you're going to believe. The chief of police,
denied it?
They didn't deny it as such.
Mr. Thomas, before you sit down, what have you got to say about the food, the lack of food? Now, as I understood Mr. Bratton, I understand the briefs, this man was arrested about 10 o'clock Wednesday morning. He was given no food on Wednesday. He was given a sandwich, I think your witnesses say 2 sandwiches, at noon on Thursday. And then nothing more to eat until after he confessed on Friday afternoon. Now, what do you have to say about that?
There is no testimony in the record on behalf of the state that shows whether he was fed or not. The Chief Young testified that the first meal in the morning at the jail was at 8. The evening meal started around between 4 and 5.
And they took him about 6 o'clock to Little Rock.
Yes, sir. But
so he had no breakfast.
The record positively shows that he was fed 2 sandwiches, or at least 1, by his own testimony at noon that day.
Yes.
That after they had finished taking the lie detector.
6 hours after he was arrested.
Well, he was arrested on
10 o'clock on Wednesday morning.
11 o'clock on Wednesday.
About noon on Thursday, as I understand.
He was arrested on Wednesday. The sandwiches were on Thursday at noon. When that was after he had completed the lie detector test and was turned back over to the police officer. They fed him and returned him to Pine Bluff, where he was placed in jail for the remainder of the night, which would indicate to me that he was there at the time that the food was served. Certainly he was there the next morning, because he wasn't taken out of that cell until he wanted to confess at approximately 1 o'clock on Friday.
But he testified that he did did not receive any food, and although the state took notice of that, all they would say was that he was in the building when the others were fed.
I don't know whether they could have proved it, Your Honor, or not. As I say, I wasn't in that phase of the case. I've only been connected with it during the peak. But there is nothing, I will say that very frankly, there's nothing in the record, any direct testimony that would reflect anything to the contrary other than what the petitioner said.
Yes. Well, now, do you not think that a 19-year-old man, if you want to call him, or a boy, whichever it is, who was thrown into jail and held for 26 hours without any food, and then is given 1 or 2 sandwiches, and then is questioned off and on for another 26 hours or so before he's given any more food, and half of the time without even any shoes on, dragged around the country. Do you not think that has some effect upon his mental condition and his willingness to do what the police wanted to do?
Well, Your Honor, may I say this? I, from reading the record and staying strictly with the record, I have not drawn the same conclusions from this that you have. Like you say, where he's dragged around the country without any shoes. He was merely taken from Pine Bluff to Little Rock without shoes, where he was given shoes.
Yes, but as I read the record, your own witnesses said that his shoes were taken from him at about 6:30 in the morning. And then they took him to Little Rock, and they gave him some shoes about 4:30 in the afternoon.
Well, the officer testified that Officer Halsell testified that he gave him the shoes immediately upon his arrival at State Police Headquarters that morning. Now, it was the petitioner who said that he didn't receive the shoes until 4:30 in the afternoon.
Well, I may be mistaken about this.
But I say, according to the record, if the facts were as you stated to me, then my answer would have been different.
Well, let's leave the shoes out of it and just take that food proposition. Do you think that is conduct compatible with free and voluntary confession?
I don't think that one factor alone would affect it.
No. Well, how about
because I very frequently go that long myself voluntarily.
How about that factor coupled with the other one to the effect that the sheriff told him that there were 30, 40 people out there and he'd try to protect him?
Well, now, on the morning, on that Friday morning, I don't believe there's any dispute in the record that he was placed back in the jail on his return from Little Rock for the remainder of the night. That had to put him there the next morning. I mean, he had to be in jail the next morning during the time they served breakfast.
Well, that doesn't prove that they gave him any breakfast.
That's true.
And there's no one for the state who testified that they did give him any breakfast.
That's true.
There's no one who testified that they gave him any food at all except those 2 sandwiches 26 hours after he was arrested.
But by his own testimony, he said the reason I confessed is because I was afraid of what the sheriff told me and what the jailer at Dumas told me. He never once says in his testimony that the reason he confessed was because he was hungry.
Well, he testified the fact that he didn't get any food, didn't he?
Well, he said he had 2 sandwiches and a Coke and a candy bar and some peanuts, and testified that Sergeant Halsell, although he'd had breakfast, now this was at Dumas, that morning in jail, Sergeant Halsell, he told him he was still hungry, and he stopped outside of Dumas and bought him ham and eggs and milk.
Ham and eggs?
Yeah.
When was that? After he confessed?
Well, that was apparently after he'd confessed.
Yes.
That was at Dumas.
That makes a difference, doesn't it?
But he also fed him the day that he had him in Little Rock. Of course, it's like you say, there is no testimony to the contrary, to contradict that he said he wasn't fed.
Well, that's the reason why I ask you whether there isn't more than just the one point. You say the only issue in the case, as you see it, is what the sheriff is supposed to have told him just beforehand. But you don't attach any significance to the fact that this young man was kept in jail and questioned and night and day at various times, I don't say continuously, and that he was given no food except 1 or 2 sandwiches over a period of more than 2 days.
Well, now, the record will reflect that he was given more than just the 2 sandwiches.
Well, where
By his own testimony, he says in there that besides that he was given a candy bar, that he was given some peanuts, and on his own testimony he said that the jailer threatened him at Dumas before he confessed, and that he goes and all that he was fed before he was confessed. Of course, that isn't true because...
Well, you tell us that those things happened afterwards. So
that's
he was
true.
Mistaken about
but he still received...
He's mistaken about getting the time he got that candy and so forth in Dumas.
Well, no, he didn't say he got it in Dumas. He said he got it in the jail.
Where did you get the ham and eggs breakfast on Friday morning?
Sergeant Halsell purchased that for him outside of Dumas.
What was the defense on the marks?
Could I ask?
I don't quite follow you, Judge Wood.
Well, did he deny guilt on the trial of the case? The defense on the marks?
No, he admitted that he killed the man, but he said he said he did it in a sudden heat of passion.
That doesn't appear in this record. I sent the typewritten record this morning, and I looked at it hastily.
There is much
that
this record...
thinking that he took the stand in his own defense, apart from the confession. He admitted that he killed the man, and that the defense was that he'd done it in self-defense. Is that correct?
Self-defense and sudden heat of passion. There were 2 elements there.
Yeah. But he never repudiated his confession on the witness stand, where he testified in his own behalf, did he?
He said, I believe, that wasn't the truth, and that he was telling the truth when he testified in his behalf, that he did repudiate the confession.
Well, I don't understand that statement. Where does the confession deviate from his testimony in his affirmative defense?
It may not... you mean, how does his testimony differ from his plea?
From his confession.
It doesn't itself in that sense. As I remember the record, he said that the confession he made was not true. And the prosecuting attorney said, what is the truth? And on objection by Mr. Branton, the court stopped the prosecutor from pursuing that line of questioning any further. And I believe that testimony was taken in chambers, possibly at around 91.
Was there testimony before the jury on the affirmative defense that petitioner slew his employer?
Yes, but it is not in this record.
It's in the typewritten record that you haven't...
Yes.
You haven't printed that part of the testimony in this typewritten record. To get the whole picture of what this fellow testified to, you've got to look at the typewritten record. Is that it?
Yes.
Is the $400 of the employer's money that was found in the petitioner's home, is that evidence of that in this record?
Yes, it is in this one, and the other one too, and the typewritten. It's in both of them.
Did he admit or deny he got the money?
Well, he took the officers, very frankly admitted that he took it and took them to where he had it hidden in a piano.
You're talking about the confession.
And also there's some other testimony, and I don't know whether it's in this particular record or in the typewritten.
But his typewritten testimony, his typewritten record, he admitted that he took the money, didn't he?
Yes.
Testified affirmatively for having taken the money.
He even took the officers to the spot that he'd thrown the iron rod where he crushed his employer's skull and pointed out, this is where I threw it, and that's where a man had found it. There was ample independent evidence which he can been convicted of other than the confession.
Ample independent evidence was there, but he denied that he had made the confession that they offered against him.
No, he never denied making the confession.
I mean, as they stated it.
He said that wasn't the truth, but I don't think he... And then in the other record, the typewritten record, he tells his story that is different than the confession. Thank you.
Mr. Branton, you may finish if you wish, like, so you won't have to come back.
May it please the court, I notice that there has been considerable questioning back and forth as to what the chief of police meant about whether or not there were 30 or 40 people downstairs just prior to the confession, I wish to point out to the court that on the bottom of page 113, on cross-examination of the chief of police by myself, I specifically asked him this question: state whether or not anything was said to the defendant to the effect that there would be 30 or 40 people there in a few minutes that wanted to get him. His answer was, I told him that would be possible, that would be that many. It was possible there could be that many. I think that clears up what the chief of police meant, because certainly the question was, if you told him there'd be that many people there to get him. Now, the state contends that what he meant was be 30 or 40 people there to witness a confession. And certainly if you use the language to get him, it can't mean but one thing, namely just what it implied, that there would be possible mob violence. The defendant specifically repudiates his confession on page 94. It does not appear in the transcript of record printed here as to the defense on the merits, for the simple reason that the only part of the record here is that part designated by the petitioner. And naturally, the petitioner was only going to designate that part that this court would consider on certiorari, and we didn't feel that we should make out the state's case. They failed to cross-designate. It's not here. The defendant took the witness stand in his own behalf, admitted to the slaying, but states that he was working there, that he and his employer got into a very heated argument, that the employer slapped him, and that he reached down for an iron bar, and that he jumped over this counter, that they fought over it, he got it away from him and beat him with an iron bar. And when he realized what he had done, that his first thought was to get away, and the man was there checking up, and he took some money. Now, it should be remembered that this defendant was not charged with the crime of murder in the first degree while in the perpetration of a felony, because the state would have had an easier case in the Arkansas law, no premeditation being required. Now, they tried to imply here that he was charged with robbing the man, but he wasn't even charged with that. It's true that he had the $400 and some odd, but he was never charged with a slaying while in the perpetration of a felony. And that is significant.
Did that testimony involve in the record that without objection, he had to pay $400 on the seat?
Oh,
In other words, was the amendment for the indictment or the information amendment part of the truth?
no, sir.
By the fact of silence as the testimony went in.
Well, Your Honor, please, we objected to the information in the first place because...
Well, did you object to the evidence that $400 of the deceased money was found in the home of the deceased?
We objected to the testimony of Sergeant Halsell, who first testified to that. Yes, sir, we did. But if you have reference to the objection of the possible commission of other crimes, insofar as that angle is concerned, we did not raise that as a legal question. As to that payroll record, the payroll record accurately reflects the actual number of persons who served on the jury in Jefferson County. And therefore, in answer to a question as to the number of Negroes who served the preceding year, one commissioner said that he couldn't use all of those who'd been used the year before. The record shows that only 2 or perhaps 4 had been used the year before. Anybody who had been excused would not be on the payroll record and therefore could be used on the next panel. The testimony as to that payroll record is uncontradicted. The state says that we don't know how to add, and that the total number there is 640. We still get 669. We attempted to put the sheriff on the stand. The record, the permanent record, is kept not in the sheriff's office, but in the office of the circuit clerk, the same person who said he had no such record. And the court didn't even want us to burden the trial, because, after all, we've been in court for half a day, and if you take longer than 2 days in Arkansas to electrocute a Negro, why, then you have an unusually long trial. So we wound up in 2 days. The court didn't want this trial delayed and suggested that I get on the stand and testify. Now, we submit that after having been invited to make this testimony, and certainly we had the burden, then the burden of rebutting that presumption which we had raised was on the state, and they offered no testimony whatsoever to rebut the evidence which we had offered. As to whether or not there were more Negroes excused from jury service as compared with white, the record is silent. As I say, we'd have to go outside the record, but certainly the percentage of Negroes who serve would be even more disparaging if we use the accurate record rather than the payroll record. And even if that was not true, there's nothing here. The state says that people get excused for toothache and having babies and this, that, and the other. And I don't think that this court can take any judicial knowledge of the fact or be presumptuous enough to say that Negroes have any more toothaches than white people, and that therefore a greater percentage of Negroes would ask to be excused than would white people. And as to the inference that might be raised by such a situation as you have in Jefferson County with such a small number of people, Negroes being called for jury service over a long period of time, this court said in another decision coming out of Texas that it should tax the credulity of the court to say that mere chance resulted in such few Negroes being called for jury service in a county where you have such a high percentage of Negroes making up the population and a high percentage of the qualified voters. Another question was directed to the Attorney General as to whether or not in Jefferson County you would find an unusually high percentage of illiterate colored people in that county. Now, I've lived in that county all of my life. Insofar as Negroes are concerned, Jefferson County is the leading cultural and educational county of the state of Arkansas for Negroes. It is the home of the Arkansas State College for Negroes. It is the home of Haygood Institute for Negroes. For many, many years, the Negro High School has been accredited by the North Central Association. And I dare say that percentage-wise, there is a greater percentage of literate Negroes in Jefferson County than any other county in the state of Arkansas, and that the literacy qualifications of Negroes is probably equal to or superior, percentage-wise, than the literacy test of white people in that county, because there is not a single white college within that county. And certainly, any time that you have a county where you've had a college down through the years, there generally is a higher literacy quotient in that particular county than you have in a county where you do not have a college.